Yes, Ms. Buttercup.
Milady, before I dive into the case law of the European Court, there are three documents advising our discussions this morning, which I'd like to hand up if I may. The first two are care plans that were in place at the time of Jackie's death. The first one is the United Response Care Plan, which is the one that's incomplete and which would have been held within the care home. The second one is the Blackpool Council Care and Support Plan, which we believe would have been within Blackpool Council's records and not at the care home. And a third document is the 111 transcript that I've already taken you to in the evidence, but is the neat transcript. We've numbered all of them consecutively at the end of the supplementary bundle.
So, end of supplementary bundle 2.
Yes.
Very good.
And if the court wants to look briefly at those care plans while they're being inserted, the United Response Care Plan, the pages that we have don't contain anything about medical treatment or healthcare at all.
No.
And are really just one sentence statements about the objective of the care plan rather than how the care would be implemented. And then the Blackpool Council Care Plan, it is just the same information pretty much cut and pasted in each day of the week about the routines that Jackie has and the number of staff she needs to help her with the activities of daily living.
Is there a date on this? Blackpool 1.
Okay. Our date plan completed on the second page at the bottom, 25th of March 2015.
Oh, yes.
Which is obviously a few years before Jackie's death, but it may be that it hasn't been updated annually as it should be.
So there's no completion of the needs, no completion of identified risks.
No.
And therefore the contingency plan, whilst it may reflect funding,
Yes.
doesn't reflect anything that this court's concerned with.
No. And as I say, not only do we not have the missing pages of the United Response Care Plan, I don't think we know what a blank version of that form would have looked like, so we're not even sure what was on pages 4 and 5, just page 4 and 6, to be able to see what we might be missing.
Yes. And a question, the answer to which may be entirely obvious for you, but less for me. This care and support plan, what's the statutory underpinning for it? In other words, what statutory power are the council exercising?
So the council has obligation under the Care Act to assess the needs of someone who appears to be in need of support.
Yes.
And they then have an obligation to produce a care plan based on that needs assessment.
So that arises out of the Care Act.
Exactly. And the United Response as the provider are not the producers of the statutory care plan.
No, that's a practical
providers
thing.
have exactly day-to-day care plans, and they may have more than one,
Yes.
dealing with specific areas where the person needs support.
Yes. Thank you.
They may also have other document risk assessments and so on as well alongside a support plan.
One would imagine so. Yes, thank you.
Just also to make clear, and second Miss Watson, and she can address you further on this, that the coroner did have all of Jackie's GP records before him at the inquest, as well as these two support plan or care plan documents. The next issue was just to respond to my lady's question about the real and immediate risk. On reflection, it wasn't clear to me that a risk couldn't both have accumulated over the 21st of February and crystallised that evening. But getting to what I think is the nub of my lady's question, it's apparent from the evidence that the carers became more and more concerned as the afternoon went on. And one sees that in the 111 call at 7:15, saying, I just need someone to come and see her, because they hadn't been able to get the GP out. No one was actually coming to assess Jackie face to face. And so the carers were certainly aware that she was sufficiently unwell that someone needed to come and see her, and they were getting increasingly agitated about the lack of response. There'd been not only the earlier 111 call, but also a call to the GP surgery earlier in the day. But certainly by the time the paramedics had attended and carried out the medical observations that the care staff weren't qualified to carry out, then that added to the other information was easily enough for there to be pretty clear that there was a medical emergency. And I should say that I think earlier I was unhelpfully conflating the two risk concepts that are relevant here. The real and immediate risk, when once established that in principle the operational duty could apply, but then in that first stage, the nature of the risk that the person is exposed to, which is more to do in this case with the systems or the lack of guidance and the lack of understanding about meeting the needs of this particular population. So, as indicated, there are 4 European court authorities, including one that Ms Watson has produced today. Before we start, none of them have very similar facts, and none of them are obviously consistent with each other in the sense of setting out clear principles that could be applied from one to the other. It is, as ever, a case of looking through them and then trying to work back to figure out where the differences might lie, it not always being evident on the face of the judgment itself. So the first one is the Polish case. I'm afraid I don't know how to pronounce it, but spelled D-Z-I-E-C-I-A-K, and Poland at tab 28. And this is a case where the applicant, the victim, had been arrested by the police and was kept in detention for a long period of time, a number of years, awaiting a trial. And he was already known to have heart problems. And while he was detained by the state because of the pending criminal proceedings, he was kept in a variety of settings, prisons, hospitals, and so on. And at various points, it was indicated on assessment by doctors that he required heart surgery. That heart surgery was never given to him, and he ended up collapsing at his trial and dying shortly after that. And the court in that case, and this is at page 931, reiterated its standard statements about the general requirements of Article 2, the positive and negative obligations. Then goes on at paragraph 90 to deal with prisoners in particular, noting that they're in a vulnerable position and that the authorities have a duty to protect them, and that if someone is taken into custody in good health and injured on release, that must be explained. And the obligation to account for the treatment of an individual in custody is particularly stringent where that individual dies. Then at paragraph 91, the right of all prisoners to conditions of detention which are compatible with human dignity, and towards the bottom of that paragraph, not just their health but also their well-being. And then, although there's no obligation to release detainees on health grounds, there is an obligation to protect the physical well-being of persons deprived of their liberty, for example by providing them with the requisite medical assistance.
Yes, so 91 and 92 are Article 3 points.
Yes. This is...
Sorry, 91 is an Article 3 point.
Oh, conditions of detention.
Prison
yes.
conditions, essentially.
Yes.
Yeah.
But in this case, the court doesn't look at any of the medical negligence case law or anything of that sort. And when one gets to paragraph 101, they, just above paragraph 101, they say that the applicant's health was clearly serious. He'd been detained for 4 years. His health was more and more a cause for concern and impact of detention, and that's enough to conclude that the quality and promptness of the medical care put his life in danger. Lack of coordination, failure to transport him to hospital for operations, lack of information about his state of health at the trial court, no access to doctors in the final days of his life, and not taking into account his health when extending his detention, all of that constituted a violation of the obligation to protect the lives of persons in custody, violation of Article 2. So, didn't need to get into the realms of medical negligence.
So this is a straightforward detention
It
case.
exactly seems to be saying the mere fact of the detention is sufficient, and also isn't saying this is a case where it was known there were problems in the system with how healthcare to detainees was provided. It's purely this person needed medical attention, didn't get it, Article 2. The next one at tab 29 is the case of Valentin Campianu in Romania. And this man was someone who had been abandoned at birth and had grown up in state care for his whole life. He was HIV positive and he had a profound intellectual disability with an IQ of 30. He died eventually in a very unpleasant state, having had little or no care, let alone medical care provided to him. Much of the judgment deals with the status of who could bring the complaint on his behalf, but on Article 2, the court starts at page 992, again setting out the general obligations, but this time making reference to the healthcare case law and the requirement to have regulations in place and so on. And then towards the bottom of 992, the second paragraph are dealing with the circumstances where the risk is from the criminal acts of a third party. And then drawing all of this together in 131, the court must subject declarators to rights to the most careful scrutiny. Again, persons in custody are in a vulnerable position, and where the authorities decide to place and maintain in detention a person with disabilities, they should demonstrate special care, guaranteeing such conditions as correspond to his special needs resulting from his disability. And then at 132, noting that this isn't just about the operational duty, but also the effective and independent judicial system.
Okay, so just pausing there,
Yes.
if we may, on the facts.
Yes.
The deceased here was by the time of his death, he was an adult, but effectively detained.
Yes.
So the equivalent of a detention under the Mental Health Act here, albeit the circumstances were rather different. Would that be a fair?
Yes, possibly also similar to detention under the Mental Capacity Act here, because
Yes,
of course one could be detained in a psychiatric hospital here under the Mental Capacity Act.
20 or 25.
So, and clearly the facts in this case are appalling in terms of the absence of care.
Yes.
They are absolutely shocking. What the court goes on to look at it in the case, it therefore includes what was known about the appalling conditions at the particular hospital where this man had been placed. And that starts at paragraph 141, noting that all sorts of independent reviewers had pointed out what was going on, and that the domestic authorities were therefore fully aware of the very difficult situation in the hospital, and had even acknowledged before international bodies the deficiencies about basic things, heating and water, living and sanitary conditions, and medical assistance. And then paragraph 142, the court refers back to the case of Menchaver and others, and says that, as in that case, the court took into account the fact that the children's death was not a sudden event, because the authorities had already been aware of the appalling living conditions in the social care home. And similarly here, the response to the appalling inadequacies was not good enough, because they were fully aware of the problems. And as the court says, it's therefore all the more evident that by deciding to put him in that hospital, even though he was already in a heightened state of vulnerability, they unreasonably put him his life in danger. And then the continuous failure of the medical staff to provide him with appropriate care and treatment was yet another decisive factor leading to his untimely death. So they seem to be saying, on the one hand, it was the knowledge of the appalling conditions and the decision to place him there that engaged Article 2, but that also another decisive factor was, once there, a continuous failure to provide him with medical care. Although, as we'll see later, whether that's the right interpretation is cast into some doubt by a more recent authority. So that was the decision in his case, unsurprisingly perhaps, that Article 2 was engaged. And the next
Is the additional context there, if we go back to paragraph 132, given the position of the government, which was in effect to deny the conditions
yes,
in Romania, the last sentence there, Article 2 of the Convention will not be satisfied with the protection afforded by domestic law exists only in theory.
yes,
Above all, they must also operate effectively in practice.
Yes,
That probably explains.
yes,
Yep.
yes. Then the next case is the next case in the bundle at tab 30, Jasinskis and Latvia. And this concerned a young man who had been deaf and mute since birth. And he sustained a head injury while out one evening. He was found unconscious and the police and an ambulance were called. When the police arrived, they appear to have misinterpreted his arm gestures, because he couldn't communicate by speaking to them, as drunkenness, and he was taken to the police station rather than for medical attention. He was locked in a room in the police station, and even though he didn't wake up in the morning, it took a very long time for anyone to call for medical assistance, and he died. And the decision and the analysis of the court in that case is at page 1034, which is paragraphs 56 onwards. And that again repeats the similar general comments about Article 2. And again in paragraph 60, as we've seen before, the obligation to protect the health of persons who've been deprived of their liberty. And then two rather generic statements. The obligation to protect the lives of individuals in custody also implies an obligation to provide them with the medical care necessary to safeguard their life, and a failure to provide adequate medical care may constitute treatment in breach of the Convention. That last sentence on its face seems to be completely incompatible with the Fernandez and Parkinson approach, but the court is talking here clearly in the context of people who have been deprived of their liberty, not in that standard medical healthcare context.
And the may is important as well.
And then their conclusion is over the page, paragraph 66. The government have failed to explain any of this. The police had a clear obligation to help them communicate. They took too long to call for an ambulance. And all of those considerations enable the court to conclude that, given that the police knew that he'd fallen over and had a sensory disability, their failure to seek a medical opinion about his state of health and their failure to react to him not waking up meant that they had failed to their duty to safeguard his life by providing him with medical treatment. And then the last case is the one that was handed up this morning, which is the case of Dumper and Latvia. And then this is an admissibility decision.
I've forgotten where we put it. Is it
I
right at
think
the back?
right at the end.
Yep.
So this is not a full judgment but an admissibility decision, and it concerns a person who had Down syndrome and epilepsy, and who had been in a state social care home since about the age of 16. And he had not only mental disabilities, but also a range of physical conditions as well. And what is said in the outline of the facts was that the mother skin disorder was getting worse. And that from paragraphs 10 onwards, that there was a period in April 2012 when he became more and more unwell and subsequently died. And the conclusion was that he had died of a range of things, including the skin disorder, heart problems, epilepsy, bed sores, and so on. Essentially, he was in an appalling physical state when he died. The judgment then goes on to explain the criminal proceedings which took place, which concluded that there'd been no criminal offences. But then there was an investigation by a health inspectorate which concluded that actually there had been regulatory failures. And as a result of that, there was disciplinary action against some of the people responsible. And then we see the complaint in the way it was put by the applicant at the bottom of page 11, paragraph 48. She complained that her son, who had been placed in a state social care institution, had died because he had not been provided with adequate medical assistance. In particular, the personnel and the general practitioner hadn't reacted to the deterioration of his health condition. And the investigation into his death had just concentrated on negligence, but not the underlying care that had been given previously. And the social care home that he was in was one which had its own medical staff as part of it. So these were sort of internal general practitioners and so on who should have been assessing him. Now the court in this case decides that Article 2 is not engaged, and the reasoning is all dealt with in terms of the government's argument that there had been a failure to exhaust the domestic remedies. So that's where paragraph 49 starts, and the government says that she had the right to seek compensation, there'd been criminal proceedings, and all of that was adequate. She obviously objected to that, but the court found against her. And from paragraph 55 set out their reasoning for that. So paragraph 55 explaining about the need to exhaust domestic remedies. And then paragraph 56, there's nothing to indicate that the death of her son was caused intentionally, so that aspect of Article 2 isn't in play. Furthermore, this case should be distinguished from cases where the domestic authorities have been aware of the appalling conditions that later led to the deaths of young people. So distinguishes the cases we've seen of Valentin, Campiner and Mencheva because it hadn't already been brought to the authorities' attention that this place was completely unsuitable. And then the court distinguishes the Jasinski's case, which is the young man who had the head injury and was kept in the police cell, as saying that that's different because although, again, there wasn't a concern about information having been drawn to the authorities' attention, that was about the authorities' failure to provide a detained individual with the emergency medical care necessary to safeguard his life. They seem to be saying that the fact that the medical care is required on an emergency basis is of some relevance. That is then explained further in paragraph 57 by saying, in contrast, here the applicant is arguing that her son died owing to the social care home, and in particular its medical staff's failure to provide him adequate medical care when his condition deteriorated, and therefore her complaint is a medical negligence one. The only way I can make sense of that is that the word emergency is the key bit in paragraph 56, and that they're trying to differentiate between cases where there's an ongoing failure to provide medical attention and a case where someone's condition clearly calls out for medical attention but it isn't given to them. Otherwise it's difficult to see exactly what the difference is in my submission that they're drawing between those cases. And then they go on to say at 58, the applicant wasn't arguing that there was a failure to put in place an effective regulatory framework, and her complaints didn't fall within the exceptional circumstances in Fernandez. And so they would just look at it in relation to the adequacy of the mechanisms in place in Latvia for looking at what had happened. And then they conclude that she could have gone for a civil law remedy, it was still open to her, and so it was inadmissible for non-exhaustion of domestic remedies. At the risk of repeating myself, I warn, but I'm not sure that these cases really assist enormously because they clearly don't generate clear criteria, thresholds, or frankly anything else that can be reliably translated from one set of circumstances to the next. They do show, as the Supreme Court found in Raybone, that there is something different to Fernandez and Parkinson in the medical line of cases. There are cases where you don't go down that path. The most obvious and straightforward ones are prisoners who are in custody and don't receive medical care, but they do also extend to other circumstances, and I've already taken you in Raybone to the Watts case and so on. So one ends up perhaps in a position that one can find support from a range of cases for any position one might want to put forward, because there are, depending on the facts, cases where the court goes one way or the other. But in my submission, none of those cases show that anything that the Supreme Court said in Raybone is wrong. And if anything, they perhaps assist, my Lord, in the question of, well, where does one put any limits on this, by suggesting that emergency care, where someone's condition clearly calls out for it, is perhaps in some different category or is some relevant and important factor which may need to be considered in a case where you don't have pre-existing concerns of which the authorities are aware. But as I say, trying to draw from these cases a definitive answer one way or the other, when none of them involve very similar circumstances, it is rather taxing. So, just drawing round one together, my Lords and Lady, I think, have the submissions that I make on behalf of the appellant. I've dealt briefly, but I think sufficiently, with the coroner's decision, where none of the Raybone factors were looked at, nor was this case law considered. The divisional court's decision is slightly different, because they do seem to have accepted that Raybone might have been relevant. The judgment is at A81 of the core bundle. And their analysis of Article 2 starts from paragraph 30. And the court does, at paragraph 33, refer to the European case law that I've just taken this court to. And then in paragraph 34, the court says, where Article 2 is engaged in this way, the individual to whom the positive obligation is owed by the state is vulnerable in the sense that he or she is under the control of the state and unable to get away from the dangers posed by detention. And the state must be regarded in these circumstances as having assumed responsibility for the individual's safety and for preventing death. Which comes close to giving some clear guidance about circumstances which will always entail a sufficient assumption of responsibility, but couldn't be said to be a comprehensive account of those circumstances.
They refer to Savage at
Yes.
28.
Yes.
Yeah.
But we know from Raybone that there are cases where Article 2 being engaged where it's not the fact of the detention and the inability to get away from it that has been the problem. So again, these attempts to try and state in a sentence or two what it is that the testers don't work, because they just can't incorporate all the different scenarios where Article 2 has been found to engage. And Savage, of course, is the case about, another case about psychiatric patients.
Just looking at 28.
Yes.
Yeah.
So that, I think, is an attempt to just restate general principles, although my submission is a bit too simple to really convey and cover the variety of cases where Article 2 has been found to be engaged. But that may be just because really all the court is doing is referring back to paragraph 33 and referring to those limited examples. Then the next paragraph, they go on to some of the other situations where Article 2 has been applied and include there Watson, UK and Raybone. And then in 36, they refer to the De Oliveira at Portugal case, which is in the bundle, essentially as a case where they found, as in Raybone, that Article 2 could apply to a voluntary psychiatric patient at risk of suicide, but on the facts there was no real and immediate risk because it wasn't foreseeable that the person would actually take their own life. Then paragraph 38, the coroner in the present case applied the guidance in Parkinson, which states that provided you have a proper system in place, errors of professional judgment and negligent coordination won't engage Article 2. And then Parkinson is now authority that a medical case in which negligent medical treatment may incur liability and tort will not generally engage Article 2, which might be right if you're not talking about a detained psychiatric patient, but clearly isn't right if you're talking about all possible cases where healthcare is an issue. Then paragraph 39, the positive duty won't always be engaged just because someone's detained or is in the care of the state. And clearly there's got to be some evidence that there has been a failure to protect life, that must be right. And then in our view the following principles emerge. Article 2 may be engaged if the state had assumed responsibility for the individual's welfare or safety, which appears to be an application of the first Raybone factor, but none of the others. And then secondly, paragraph 41, in deciding whether there's been an assumption of responsibility, the court will consider how close was the state's control over the individual, and the paradigm example is a psychiatric hospital. Now, in my submission, that doesn't begin to cover what is said in Raybone and the case law about how to assess whether or not Article 2 is engaged in a non-Parkinson case. And so, painful though the process is, whatever conclusion my lords and my lady come to, the requirements of Article 2 do need to be spelled out comprehensively in order that coroners can understand what the guidance is that they should be following. Then, in terms of the court's conclusion and reasoning,
It may be wrong, but it looks as if the telescope down which the divisional court were looking is constrained by the fact that the coroner doesn't deal with factual matters that would have exampled the distinct vulnerability that Jackie had. Because had that been set out, the divisional court would have approached it through a different lens. That bit's missing.
Maybe right. When one gets the analysis and conclusions, the court concludes in paragraph 44, unsurprisingly, that knowing whether something other than the paradigm example engages Article 2 is hard to define. The conclusion is that the touchstone for state responsibility has remained constant. It is whether the circumstances of the case are such as to call the state to account.
I'm so sorry, where are you reading from?
Paragraph 44.
44. Yep.
And in the absence of either systemic dysfunction arising from a regulatory failure or a relevant assumption of responsibility in a particular case, the state will not be held accountable under Article 2. If one takes relevant assumption of responsibility to incorporate all of the Raybone factors and the other considerations, that might be right. The difficulty is that, again, it doesn't assist with do these circumstances, are they such as to call the state to account or not? What the court then goes on to do is to say we've looked at the chain of events in the days before Jackie's death. They note a number of the problems that have arisen, including the paramedics who had not been notified that Jackie had Down syndrome and who found themselves unable to take her to hospital, and that say that those were all potentially matters that could give rise to individual civil liability or professional disciplinary proceedings, but they're not capable of demonstrating systemic failure or dysfunction. So that's their second possible Raeburn criteria. And so saying that the coroner's approach reveals no error of law, in my submission, is just untenable.
So the short point is looking at paragraph 49, where it is said by the court, however, it was the function of the coroner to draw it. You
Yes.
say that's what he didn't do.
Yeah, he didn't do it at all. It's not that he did it wrongly, he didn't do it at all, because he was heading down the Parkinson line of authorities. So, that's ground one. There was a failure to apply Raeburn. If it had been applied, the answer would have been that Article 2 was engaged. Ground two is in the alternative that Parkinson applied, not Raeburn, and that the exceptional circumstances were present. I referred earlier to one issue in the Parkinson decision itself. Parkinson is at tab 25 at the end of the second authority chapter. And essentially just repeats the decision of the Grand Chamber in Fernandes and Portugal and includes a lot of its reasoning in the actual judgment. The court will almost certainly want to read all of this case, but there's no argument from me that Fernandes and Portugal is wrong or that the court shouldn't follow it in some way. I accept that that's the test when one is in a healthcare case. And the only perhaps pedantic point, but I think again important just because these the guidance that the court gives is so easily cut and pasted and lifted and used again. It has to be 100% accurate. Paragraph 71, these are the very exceptional circumstances as defined by the European Court in the Fernandes case, where notwithstanding that it's a healthcare case, you might have an Article 2 issue. And they set out two types of circumstance. The first one is where someone's life is knowingly put in danger by denial of access to life-saving emergency treatment. And the second is where there's a systemic or structural dysfunction in a hospital service which results in a patient being deprived of access to life-saving emergency treatment.
So the critical word there is knowingly in the first one.
Yes, and also the absence of any reference to systemic problems having to be demonstrated. It's almost like the first one is appallingly bad practice, gross negligence, whereas the second one is systemic failure. And the reason I flag it up is just that when the court then from paragraph 82 summarises the relevant principles, I don't take issue with any of that, but in paragraph 88 the court says that there may be exceptional cases where emergency medical treatment is not given. That's exceptional circumstance 1, and then they say that failure will result from a dysfunction in the services and this will be a structural issue, and so merge the two there. Now, for the purposes of this appeal, I don't think the court has to decide whether or not the European Court was actually identifying one type of exceptional circumstance or two, but in my submission, based on what is set out from the Fernandes judgment, the court did seem to be trying to draw a distinction between two types of exceptional circumstance that weren't the same as each other. So that's the only minor point about that. So really our submissions in relation to Parkinson are not that the case is wrong or anything of that sort. They are that the coroner's conclusion was wrong. And the reasons for that are ones that have actually already been canvassed in relation to ground 1. The questions that one has to ask when one's in this territory is firstly, was there a failure to provide treatment? And we say, yes, there was a failure to take her to hospital. The medical treatment and assessment. Were people aware that her life was at risk? Again, we say they would have been. The paramedics wanted to take her to hospital, the care staff were very worried about her. And the third question, was there a dysfunction in the services linked to deficiencies in the regulatory framework? What was said to the coroner was that, well, we have the Mental Capacity Act. That's a regulatory framework, and that's adequate. And because we have that framework and the paramedics were aware of it, there can't be a systemic failure. In fact, the evidence and the submissions from the coroner were almost that the Mental Capacity Act was a hurdle in some way, or an obstacle to providing care, because it meant you couldn't apply disproportionate force to take someone to hospital, or it didn't give you any other options. In fact, completely the reverse is true, because what the Mental Capacity Act does is to give you a defence to acting in someone's best interest when they lack capacity. It doesn't spell out anything that you can or can't do in particular, other than to require you to turn your mind to whether you have a reasonable belief that the person lacks capacity and that what you're doing is in their best interests. So the fact of that framework isn't enough to say, well, there can't have been a systemic problem because we have a Mental Capacity Act. And that's evident from what happened. We do have a Mental Capacity Act, we even have the Dole's safeguards, and yet we have no guidance and no care plan to enable Jackie to get emergency medical treatment. And we said when we looked at all of those factors, yes, Dr. Fairhead made a mistake by not asking more questions, but actually the system wouldn't have worked even if she had asked those questions, because there hadn't been any proper thought given to the particular circumstances of someone like Jackie, who was going to need special care taken in order to actually facilitate her going to hospital, receiving emergency treatment. Most of that. Unless there are any questions, those are our submissions.
Thank you very much indeed. Yes, Mr. Bear.
Lady, the coroner agrees that there is a need for clear guidance from an appellate court as to the applicability or the approach to applicability of Article 2 in relation to cases where an individual dies of natural causes, but there were errors in the healthcare provided to them or not provided to them, where they are vulnerable and in circumstances where their liberty could have been restricted but was not on the facts relevantly restricted to the cause of death. In our skeleton argument, we sought to identify from the extensive, and it's got to be acknowledged, on occasions not entirely clear, case law, the underlying reasons and rationale for the court determining in the past when and in what circumstances the positive obligations arising under Article 2 of the Convention had arisen, such that the adjectival investigative duty is engaged. We would respectfully suggest, however, that the authorities disclosed in this respect that the Divisional Court gave the only guidance that could realistically be given in such circumstances, which is in paragraphs 44, 48 and 49 of its judgment, namely that the overarching and consistent touchstone for state responsibility is whether the circumstances of the case are as such to call for the state to be called to account. That cases beyond the paradigm examples, in particular the paradigm example of detention or custody, will turn on their facts, and that the line between state responsibility, for which it should be called to account, and cases involving individual actions for which it need not be called to account, will sometimes be a fine one. Now, the coroner would, perhaps above all people, be at the front of the queue those asking for guidance in the form of a series of questions or tests that fall to be applied in an individual case. Some sort of prescriptive delineation. And although such a search for taxonomy is understandable, indeed it's the natural instinct of many of us, it isn't reflective of the approach taken in the authorities. Instead, the level of scrutiny required is in any case fact-specific, as has been held by the Divisional Court and has been consistently held both domestically and in Strasbourg. The suggestion being that a prescriptive and delineated approach is inappropriately reductive. Now, consistently with the approach taken at the permission stage of these proceedings, at the oral renewal hearing, at the substantive hearing before the Divisional Court, and on the application for permission to appeal to this court, the coroner appears before the court today and tomorrow in a position of neutrality as to the outcome of the appeal. And in particular, he has made few submissions on grounds 2 and 3 of the appeal, and has concentrated instead on the law as to ground 1. I'm conscious, moreover, that there's a party before the court, United Response, represented by Ms Watson, who is in a position to take a position of opposition to that of the appellant and test some of the points that have been made. Having regard to her skeleton argument, which was filed after our own, which seems to adopt to a very great extent the submissions of law that were made, but then carries those submissions through to the facts. I'm not going to trespass on the facts at all. Accordingly, my relatively short submissions are going to be structured as follows. Firstly, trying to isolate the issue. I put it slightly differently than Ms Butler-Cole. Secondly, addressing the circumstances in which the issue arises and the consequences, which have been touched on, but I do want to stress them. And then thirdly, addressing briefly each of the 3 propositions that we set out in paragraph 12 of our skeleton argument. So firstly, the issue. We frame it as follows. When and in what circumstances the adjectival obligation arises in the context of a vulnerable person who is subject to a dole's authorisation, and so whose liberty could be restricted if necessary, who died from natural causes, but in respect of whom there were errors in the health care provided to them. I've described the obligation as adjectival. It's sometimes described as the parasitic duty, sometimes called the enhanced investigative obligation, sometimes called the duty of enhanced investigation. And we've given the references to those different ways of describing the adjectival obligation in footnote 2 in our skeleton argument. I've steered away from calling it an enhanced investigative obligation because the none of the appellant's criticism here is not the investigation carried out of the coroner, it's the end product. So the circumstances in which the issue arises, the court would have seen that the coroner conducted his investigation and the inquest until the point of seeking the jury's conclusions, as if Article 2 was engaged. And so the investigations carried out by the coroner, the experts that he instructed, the lay and professional witnesses that he called, 29 of them over an 8-day period, and the scope of the inquest that he set, were all undertaken on the basis that this was an inquest to which the adjectival duty applied. This was partly because it's a common and accepted approach among coroners. And I've given the references in paragraphs 6 to 9 of our skeleton argument, how first the House of Lords in Hurst and then the Supreme Court in Smith made clear the distinction between the scope of an inquest on the one hand and its conclusions or its verdict in old money on the other. It's also got to be said partly because of the timing by which the authorities fell from the Grand Chamber of the European Court of Human Rights and from the Divisional Court. The court may recall that the coroner had scheduled his second pre-inquest review for the 18th of December 2017. The cross-reference to that is Core Bundle 1, page 327. And the parties were due to make submissions on the application of Article 2 in the Convention. But that, as it turned out, was the day before the Grand Chamber handed down its decision in Fernandes and Portugal, judgment being dated the 19th of December. And the court will, I think, have seen that the inquest was due to commence on Wednesday the 20th of June 2018, and the Divisional Court handed down its judgment in Parkinson on Friday the 15th of June 2018. You will have also seen that the coroner decided not to take a precipitous decision on day one, on the Wednesday, the 20th, as to Article 2. And instead, no, let's just carry on as if Article 2 is engaged. We'll review matters, we'll draw stumps at the end of the case, when all of the evidence has been heard. The coroner said, this is Core Bundle, page 398, B to C, we're going to have an Article 2 compliant inquest. When we've heard all of the evidence, we'll see whether it's an Article 2 case or not. And so it is that the investigation which the coroner undertook is not said to have been anything other than fully compliant with the requirements that Article 2 imposed. We've set out, I'm not going to repeat them, in paragraph 4 of our skeleton argument, in a series of sub-paragraphs, the things that the coroner did, and we've given the references to each of them pursuant to that duty. And so the issue in the appeal instead focuses right at the end, when the funnel narrows, only on the coroner's decision applying the Galbraith Plus test as to which conclusion or conclusions to leave to the jury. Now, we've sought to set out in our skeleton argument what the result or the legal consequences are following a determination at the end of an inquest that the adjectival duty either does or does not apply. And there are three of them really. And if I could just spend a little time on this. First, and most obviously, perhaps most fundamentally, how the deceased came by their death ceases to mean by what means and becomes by what means and in what circumstances. Just to ground that in the authorities, if we can look things up, Middleton in Authorities Volume 1 at tab 7. Page 212, sorry, 202. Paragraphs 35 and 37. And this is in the speech of the late Lord Byng. Only one change is, in our opinion, needed to interpret how, in the Act, in the broader sense, namely as meaning not simply by what means, but by what means and in what circumstances. 37. At the foot of the page from H, or in between G and H, a verdict such as that suggested in para 45 below embodies a judgmental conclusion of a factual nature directly relating to the circumstances of the death. And so the first consequence is a differential meaning of the word how applies, depending on the circumstances. Now that's now reflected in the statute that governs the work of coroners, the Coroners and Justice Act 2009. If we can just briefly turn that up and see a statutory reflection of what Lord Bingham decided. That's in Authorities Volume 1 at tab 3. And it's necessary to read section 5 with section 10. So on the added pagination, that's pages 59 and 60. Section 5, as Lord Chief Justice mentioned earlier, there are 4 statutory questions in section 5, and we're dealing with 5.1b, how the deceased came by his or her death. So that's got to be read alongside 5.2, where necessary, in order to avoid a breach of any convention rights, the purpose mentioned in subsection 1b is to be read as including the purpose of ascertaining in what circumstances the deceased came by his or her death. So the differential meaning of the word how, heralded by Middleton, finds statutory force here. That's carried through from the purpose of the inquest to the conclusions over the page to section 10. Section 10.1. After hearing the evidence, the Senior Coroner or the jury must A. make a determination as to the questions mentioned in section 5.1b and then read with section 5.2 where applicable. Thus, the broader approach to the word how may only be applied when it's necessary in order to avoid a breach of any convention right. Where it is necessary to avoid a breach of a convention right, the range of facts and matters that may be permissibly addressed in the jury's conclusion, its verdict, is considerably broadened. This may include the causes of death, defects in a system which contributed to the death, and any other facts relevant to the circumstances of the death. The second consequence of a finding that the adjectival duty applies to the conclusions of an inquest is that the content of the conclusion, the content of the verdict, may be expressed using different language than would otherwise be the case than if the enhanced duty did not apply. I already took you to paragraph 37 of Middleton. The conclusion may be expressed using judgmental language of a factual nature. Middleton at 37. And a good explanation of how that is carried into effect, or maybe permissibly carried into effect, is given in the Chief Coroner's Guidance note, number 17. I wonder whether we could look at that. That's in fact, slightly oddly, but it's there anyway, as an exhibit. It's in Core Bundle 1. Sorry, Core Bundle 2. At page 558. I say it's slightly odd because other of the Chief Coroner's Guidance has gone into the authority bundle, but this one happens to be. So the Chief Coroner's Guidance, note number 17, read conclusions, short form and narrative. And it's paragraph 52 of the Chief Coroner's guidance, where he explains what permitted judgmental words may be and what are off limits. Does the court have that on page 567, paragraph 52? And the footnotes given. So not only is the range of factual circumstances broadened, but what the coroner or the jury can say about them is changed. Words such as inadequate, inappropriate, insufficient, lacking, unsuitable, unsatisfactory and failure can be included within the conclusion.
Well, we get it from Middleton when Lord Bingham explained that language that is suggestive of civil liability shouldn't be used.
Is off limits.
And he gives the example relevant for Middleton. The deceased took his own life in part because the risk of his doing so was not recognised and appropriate precautions were not taken to prevent him doing so. So that was the example given.
Yes. I mean, one can see even from the way the Chief Coroner expresses himself that we've moved on a bit since then.
Yes,
but it was a matter of fact.
But the principle must be recognised that what Lord Bingham was explaining was that the statutory prohibition against giving a view that connotes civil liability must be respected.
It's not respected. Yes, and that's in fact reflected in the coroner's note at paragraph 53.
Yes.
The third consequence of the application of the enhanced duty at this stage of inquisitorial proceedings is, as I think Ms. Butler-Cole has explained already, the coroner has a power but not a duty to leave matters to the jury that will possibly, but not even probably, causative of death.
Well, before you can decide what probably caused death, if there are a number of different potential causes, then you do need to look at all of them, don't you?
You do, but in picking up the point that my Lord mentioned earlier, what this effectively means is handing over in this circumstance to the jury a very large range of may questions, because one only applies is only able to apply the Galbraith test as to whether or not such questions should go to the jury.
But it's not reflected in the conclusions, or is it?
It is. Yes, you have questionnaires that run to 10, 20, 30, or even, as in Hillsborough, 40 or 50 pages, setting out the jury's conclusion as to whether something may have caused death, or whether it probably did. You have a column of the mays and a column for the properties.
Where does that? Where do we find that in the statute?
I'm not sure what one does.
No.
But in any event, today's not the day.
It doesn't arise in this case, but it's given the whole point of Middleton was to recognise the procedural duty under Article 2, as it was called then, and explain extraordinarily carefully how small the change to practice was that was necessary to recognise that, which is then carried forward into a statutory scheme.
In the way that
In the way that, yes, so section 5(2) is Middleton in statutory form.
Yeah.
I suspect that Lord Bingham would be rather surprised to know that perhaps 40 pages of questions are being left to juries, because it seems a long way, given that the statute, if we just go back to the statute, tells us in subsection 3 that positively that neither the coroner nor the jury can express an opinion on any other matter than those set out in subsections 1 and, if necessary, 2.
Yes, I'm not here to support
No, I just
reasoning in
yes.
Lewis, but I think what might be said is that that prohibition has got to be read only after one has complied with the duty under 5.2,
Yes.
i.e. ascertaining in what circumstances, and in what circumstances is a very broad concept.
Yes, all right. But that's not, if
Not
I
for
may
today.
respectfully say so, not what Lord Bingham was saying in Middleton. He wasn't expecting juries to essentially write judgments.
No. That is what happens.
Yes, well, I'm aware
So
of
those are the consequences of a determination that the enhanced duty applies. In short, a wider range of matters to be considered in a conclusion, which in reality must be a narrative conclusion. It can't be expressed in a short form verdict. Judgmental language and a weak causation test before putting matters to the jury in charge of matters. Can I turn then to our submissions as to the law? The court will have seen, I think, in paragraph 12 of our skeleton argument, that we advanced 3 propositions as to the law relating to Article 2 in the context of the provision of healthcare, or more likely the non-provision of healthcare to vulnerable people. Proposition 1 in paragraph 12A of our skeleton seems to have been uncontroversial and is accepted, I think, by Ms. Butler-Cole. So I'm not going to move on from, I'm not going to develop it. Proposition 2 in paragraph 12 of our skeleton argument. As we seek to explain in paragraphs 15 to 23, there are 3 periods in which the law developed here. I'm not going to try and label this too much, but they are before the 4th section's decision in Fernandez, and I'll take you briefly to the decision of Mr. Justice Richards in Goodson. Secondly, the decision of the 4th section and then of the Grand Chamber, and then finally the adoption of the Grand Chamber's decision by the domestic court, principally in Parkinson. I hope by addressing matters in this way, it's a helpful way of introducing some of the underlying issues and the rationale for the approach taken by the courts in Strasbourg and then the domestic courts to the issue. So before Fernandez, could we look please at the decision of Mr. Justice Richards in Goodson? I should emphasise I'm not relying on Goodson and subsequently emerge Tyrell because my Lord Chief Justice appeared in the former as an advocate and then in the latter as the author of the judgment of the Divisional Court. In fact, that reliance was predetermined by our skeleton arguments back in October. Looking at the head note of Goodson then, it's Authorities Volume 1, tab 9. One will see from the head note in tab 9 that this was a hospital case. It was an 83-year-old man undergoing an elective gallstone removal operation at the Luton and Dunstable Hospital in Bedfordshire, in which there was a challenge to the sufficiency of the coroner's inquiry, and in particular in relation to his refusal to adjourn the inquest to call an independent medical expert witness relating to the treatment of the deceased. And if we can go please to the to paragraph 36 to start with. which is in fact what the submissions made by the Lord Chief Justice. And it's really the last sentence of 36 at the foot of the page there, to which I draw attention. If the claimant's arguments in relation to deaths in hospital were accepted, the same might apply, e.g. to deaths in care homes and to other areas of state regulation. You'll see above the submission that Manor was making. Although that appears to be something of an inter rorum submission, it is in fact the issue that's raised by this case. Put another way, if the law was extended to require an enhanced investigation in hospital cases, which was the issue in Goodson, because the deceased was vulnerable in the care of the state, and because the state had assumed a responsibility for them, then why also not in deaths in care homes or other areas of state regulation? And that finds resonance in what the Lord Chief Justice said earlier about the thousands of other elderly adults who suffer from dementia or from Alzheimer's or similar conditions in care homes. Now, Mr. Justice Richards reviewed an extensive range of the Strasbourg authorities. And I'm not going to go back to those because he did, but in 53 he looked at Ericsson in Italy, in 54 Powell and the United Kingdom, in 56 Sinienska and Poland, and in 58 Calverley and Italy, collecting together neatly the Strasbourg authorities on healthcare cases. He sets his analysis out in paragraph 59, and in paragraphs 59 Roman 1 to 6, which I would respectfully commend to the court, especially paragraphs Roman 4 and Roman 5. These conclusions have been approved in this court by the Court of Appeal in Takushis and the Inner London Coroner. If we can just go to Authorities Volume 1, the next tab in fact, tab 10, at paragraph 105. Where Sir Anthony Clark, the then Master of the Rolls, giving the judgment of the court, said that we agree with those propositions, i.e. Mr. Justice Richards' conclusions. However, it is analysed, the position is that where a person dies as a result of what is arguably medical negligence in an NHS hospital, which is important, the state must have a system which provides for practical and effective investigation of the facts. And then similarly, subject to the same rider, by Lady Justice Smith in Humberston, which is, I'm afraid, in the second volume of Authorities, tab 90. See that at 55 and 56, Lady Justice Smith sets out Mr. Justice Richards' conclusions, and then at 58 she expresses her view, and at G, alongside D, she says only in limited circumstances I depart from Mr. Justice Richards, only so far as to decline to call them exceptional, will there be a specific obligation proactively to conduct an investigation.
Sorry, where was that last citation from?
So it's
Go to
paragraph
58,
58, Lady
yeah.
Justice Smith, alongside the letter D,
Thank you. Yep.
only in limited circumstances, and she calls them limited rather than exceptional, will there be a specific obligation proactively to conduct an investigation. Those circumstances arise whether death occurred while the deceased is in the custody of the state or in the context against hospital authorities, where the allegations are of a systemic nature, such as the failure to provide suitable facilities or adequate staff or appropriate systems of operation. They do not include cases where the allegations are of, quote, ordinary medical negligence. And so the second stage was when Fernandez and Portugal itself came along. As we've explained in our skeleton argument, 5 or so years later, in late 2015, the fourth section of the European Court of Human Rights handed down its judgment on 15th of December 2015 and appeared very significantly to widen the scope of Article 2 protections to include errors of judgment on the part of healthcare professionals and miscommunication between healthcare professionals as within the scope of Article 2 and requiring an enhanced investigation. The Grand Chamber called the case in and took a different view. It held that a finding that the substantive obligation had been violated would be a departure from the existing case law of the court, and it provided what it called guidance on the very exceptional circumstances which engage state responsibility under the substantive limb of Article 2 in respect of acts and omissions of healthcare professionals. In fact, they call them healthcare providers. And so if we can just briefly look at Fernandez again, it's in the third volume of Authorities at tab 31. You will see from a head note of H1 and H2 an adequate summary of the underlying facts. It is a straightforward hospital case. Complications arising from a nasal polypectomy, leading to peritonitis, septicemia, and death. So that's H1 and H2 on the head note. And if we can just look briefly at a couple of the paragraphs that Ms. Uphold took you to earlier, 162 and 163. So 162 shows us that this was a conscious decision of the Grand Chamber to consolidate and, as it would put it, clarify its earlier learning in this area. But then there is the caveat of 163. A passage relied on by the appellant in her written submissions and in oral submissions today. I think there are probably 3 points to make about paragraph 163. The first of them is that it speaks of people who are deprived of their liberty. That's in the third line. So different considerations arise, in particular with regard to medical treatment of persons deprived of their liberty, being in a different category. That's perhaps unsurprising, as those who are detained, for all of the reasons that have been explained, about the absence of scrutiny, the requirement upon the state to explain the unexplained, have been treated by the court as being in a wholly different category. But then it continues, or of particularly vulnerable persons under the care of the state, where the state has direct responsibility for the welfare of these individuals. And that's footnoted at 32 to 2 cases, Slimani in France and the Centre for Legal Resources in Romania. that the first case, Slimani and France, is not in our bundles. It is a case involving a Tunisian man committed to be detained in a psychiatric hospital, then detained in a detention centre awaiting deportation. He died in the detention centre awaiting deportation, and the complaint was about the medical facilities and treatment available in the detention centre. The second of those cases, it's called Centre for Legal Resources here. That's the same as the Campaniu Romania case, which we've got in our bundle, at tab 29. Because it was a claim in the Strasbourg court brought on behalf of the deceased Valentin Campaniu by the Centre for Legal Resources, a campaigning organisation. So that's the second footnote. And if we just look at Campaniu, as we have seen, I think, from paragraphs 20 and 25 of the court's judgment, this concerned the death of a man in the psychiatric department, detained in the psychiatric department of a hospital. And if one is seeking to try and rationalise these authorities, a point that may be made very fairly is that this case may be best seen as one where the domestic authorities had been aware of the dangerous and appalling conditions in social care homes and indeed in hospitals, but had knowingly and unreasonably put young people there and thereby placed them in danger. And the reason why I say that it's possible to rationalise it in that way is that is how Campaniu was itself treated by the European Court in the case that Miss Watson handed up this morning, or brought to the court's attention this morning, the Dumpe and Latvia case. We looked at it earlier, may remember from paragraph 56, that's exactly how it was described when being distinguished. If the court wishes to go there and look at it, it's the last authority in our bundle, in this bundle, right at the back, at paragraph 56. This case should be distinguished from cases where the domestic authorities have been aware of the appalling conditions that later led to the death of young people placed in social care homes. See, amongst other cases, Campaniu.
This, I'm just trying to get the chronology of this one. Sitting on the 16th of October 2018, so this long post dates Fernandez.
Yes.
Doesn't refer to Fernandez, does it? Or does it?
I think it, yes, it does.
It does.
That's paragraph 55.
Right, thank you. Let's have a look. Oh, yes.
And 59. So in an attempt to rationalise the authorities, that is certainly a clear explanation from the court itself of how it regards the decision of Campaniu, which itself was referred to in paragraph 163 in the footnote of Fernandez. Anyway, back to Fernandez, which is tab 31. The court will see after a very extensive review of the authorities, the like of which one doesn't ordinarily see if one looks at pages 1014, 15, 16, 17, 18, 19. It's a list of authorities one would expect to see in an appellate appeal cases report. I'm not going to go through the court's examination of those authorities. Its holding, its ratio, appears in paragraphs 190, 191 and 192. Dealing with the exceptional cases outside the general rule. What's interesting and maybe a difficulty for the court in due course when approaching its judgment is the exceptional cases that it refers to there do not adopt the Osman operational test. And so the stepping off point for the European Court here from the general rule describes two sets of exceptional circumstances, neither of which is the Osman test. And yet I think that is what the appellant contends for here. That if, notwithstanding this case concerns the non-provision of healthcare by healthcare providers, because of Jackie's vulnerability and her circumstances, it should be treated as being within the scope of Article 2. Then, I think this is what Mr. Butler-Cole says, one applies the operational duty, the Osman test. That's not what the court has said here in relation to cases outside the general rule concerning healthcare providers. Can we turn then to the authorities after Fernandez and Portugal? It was considered, as you know, by the Divisional Court, consisting of Lord Justice Singh, Mr. Justice Foskett, and the Chief Coroner in Parkinson, which is Volume 2 of the authorities, tab 25. The last authority of Volume 2. The court rejected a submission that it should decline to follow the decision of the European Court in Fernandez. That's paragraph 78 and 81.
Just let me catch up.
Yes, I'm so sorry.
That's right. Please don't worry, but
I should have just confused matters earlier. Even more, taking you to 64 first, which set the context of what the court was later to say about Fernandez and gives a good clue as to which way it was going to go. So paragraph 64. Where Lord Justice Singh, giving the judgment of the court, says, clearly of great importance, a decision of the Grand Chamber and self-consciously deciding to review its case law. Points I think I've made already.
and on what basis was the Divisional Court being invited not to apply Fernandez?
Slender.
Yes, all right.
78 is, without deprecating Mr. Rawlinson's submissions too much, 78, where his attempt started.
Okay, let's just have a look at that. Yes, so it wasn't on the basis that it was in any way inconsistent with decisions of the House of Lords or Supreme Court. It was simply, you don't have to apply it, so don't.
Yes. Yes, so an Ulla type argument.
Yes.
And that was rejected in 81. set out the relevant principles which are to be found in the authorities, which it said apply to medical cases, rather than, I think, to the more narrow category of hospital cases. And at 88, it describes the exceptional cases as those which go beyond mere error or medical negligence, in which medical staff, in breach of their professional obligations, fail to provide emergency medical treatment despite being fully aware that a person's life would be put at risk. In such a case, the failure will result from a dysfunction in the hospital's services and a structural issue. And it describes in 89, that's a systemic failure. That, I think, probably conflates the two categories of case. One, acting in the knowledge of a known danger and deliberately risking the patient's safety. Category 1. Category 2 is systemic failure. That's certainly how the European Court described them in Fernandez. Against that background, I should have observed, because it's relevant to ground 2, at paragraph 91, the Court reminds itself of the warning given by Lady Justice Smith in Humberston that care should be taken to ensure that allegations that are, in truth, allegations of individual negligence aren't dressed up as systemic failures. Can I turn with that background to our third proposition, namely that the duty of enhanced investigation may arise where a person is detained by the state and dies in the course of detention. However, the fact of detention isn't enough for the enhanced duty of investigation to arise, and nor is vulnerability of itself. Dealing with the first category first, it's well established that the mere fact of detention by the state isn't sufficient to engage Article 2. And although we're not a detention case, my reason for looking at these is to see what test the court applies in those range of cases where it holds that Article 2 investigation or conclusion is required. So can we look, please, then at the Lord's judgment in Tyrrell and the Senior Coroner for the County of Durham and Darlington, which is volume 2 of the authorities at tab 24. A divisional court consisting of my Lord and Lord Chief Justice and Mrs. Justice Lang rejected a submission that because a prisoner died in custody, the enhanced investigative obligation arose. And so this case has similarities in the sense that it was a case of alleged medical negligence, but was a case of death by natural causes, albeit in the parallel universe of detention rather than vulnerability and doles. And if we can look, please, at paragraph 3, the claimant's argument in about the 5th line of paragraph 3. The claimant's argument is that the fact of death having occurred in custody is sufficient to trigger an obligation to conduct an Article 2 compliant investigation as described in Middleton. And then on, please, to paragraph 20. Paragraph 14, where my Lord explains negative obligation, the positive obligation, and then the subset of the positive obligation, the operational duty, known as the Osmond duty. From 19 onwards, my Lord reviews the cases relating to death from natural causes and in consequence of medical error. And then at paragraph 26, my Lord held that the reasoning of the Strasbourg Court demonstrates that the positive obligations under Article 2 encompass a duty to account for the cause of any death which occurs in custody. The procedural obligation arises only in circumstances where the responsibility of the state is engaged in the sense that there is reason to believe that the substantive positive obligations have been breached by the state. In the case of deaths in custody, the procedural obligation will be triggered in case of all suspicious deaths, including apparent suicides. The distinction between those two types of cases is principled, captured by paragraph 5 of Lord Bingham's speech in Middleton. And then paragraph 27. But then critically in 33, in the second sentence, my Lord held, I'm satisfied that the coroner was correct to rule that the procedural obligation under Article 2 did not arise in this case. It would not arise in any case where it is established the death arose from natural causes. There's no reason to believe that the state failed to protect the life of the prisoner in question. The Strasbourg authorities discussed in Daniel suggest that in the context of a natural death in custody, the responsibility of the state for the purposes of the duty to protect life will arise only if there's been a failure to provide timely and appropriate medical care to a detainee obviously in need of it. The Osmond test is applied in the context of the provision of medical care to those dependent upon the detaining authority to provide it. So in Tyrrell, the court was saying that in the context of those who died from natural causes in custody, detention of itself didn't trigger the investigative obligation. What would was satisfaction, it's an arguability stage, at the beginning of an inquest, after review of the evidence on a Galbraith basis at the end of an inquest, was the Osmond test of real and immediate risk. The Chief Coroner's Guidance, number 16, issued on the 5th of December 2014, concerned individuals who died at a time when they were deprived of their liberty under the Mental Capacity Act 2005. I'm not going to turn it up, it's in the bundle at volume 3, tab 35. The Chief Coroner's Guidance addressed the issues of whether an inquest in respect of a person who died while subject to doles will, quote, necessarily be an Article 2 inquest. And the Lord addressed that at the end of Tyrrell, at paragraphs 37 and 38. So citing the Chief Coroner's Guidance at 37, the mere fact that an inquest will be concerned with a death in state detention does not mean it will necessarily be an Article 2 inquest. But in many cases, particularly where the death is from natural causes, there will be no arguable breach of the state's duty to protect life, general duty to protect life. Nor will there be an arguable breach of the Osmond test that the state knew or ought to have known of a real and immediate risk to the life of the deceased and failed to take measures within the scope of their powers. And then the Lord held at 38. I respectfully agree with this guidance from the Chief Coroner as regards those who die the subject of doles and endorse it as a correct statement of the law with respect to deaths in custody and state detention. It reflects both Strasbourg and domestic law. So again, a reflection of the application of the Osmond test, or endorsement of the Chief Coroner's guidance, that the Osmond test applied. Those paragraphs of the Chief Coroner's guidance were of course written on the basis of an understanding of the law as it then stood, his understanding of the law as it then stood, namely that a person who was subject to a dole's was in state detention for the purposes of the Coroners and Justice Act, and that had consequences not only for Article 2 determinations, but also whether an investigation was necessary in the first place. The 2009 Act required it if somebody was in state detention, and whether it was necessary for an inquest to be held with the jury. The Act required it if you were in state detention. But the position, of course, changed with effect from the 3rd of April 2017, so that the Police and Justice Act amended the 2009 Act. I'll just better chase this down in case it's necessary for the Court's judgment. Authorities, Volume 1. Tab 4. Tab 3, rather. And it's page 63 on the numbering that's been added. I called it the amendment by the Policing and Crime Act. The Policing and Justice Act, it wasn't, it was the Policing and Crime Act 2017. If you look at section 48, 2 and 2A, which is just a definitional and interpretational section by the lower hole punch. Subject to subsection 2A, a person is in state detention if he or she is compulsorily detained by a public authority within the meaning of section 6 of the Human Rights Act. And then what was added by the 2017 Act, but a person is not in state detention at any time when he or she is deprived of liberty under section 4A3 or 5 or 4B of the Mental Capacity Act 2005.
So that had the effect of taking out of the mandatory inquest requirements
Yes.
the deaths of those subject to doles, but that statutory change doesn't affect the question we're concerned with.
No, it doesn't. I mean, it explained the coroner's comments. You may have seen it at one of the PIRs. He said, I think that last year we probably did about 80 to 90 doles inquests in this court, and the position has changed dramatically. No, of course it doesn't. I was simply putting that before the court to explain the revision of the Chief Coroner's guidance. So there must be something more than a mere deprivation of liberty. It seems from the cases that the deprivation of liberty has got to be in some way causally connected to the death. And as we've explained, or tried to explain in paragraph 26 of our skeleton argument, many of the detention cases involve a failure to prevent suicide, where the fact of the detention leads to the risk of suicide. And so what of the cases that do not involve the heightened risk of self-harm in the context of detention? We would respectfully suggest the authorities do not disclose that it's sufficient to say that it's the fact that an individual was vulnerable and at risk of death, or even that they lacked capacity, that causes the obligation to arise. And the court may think that must be right, because exactly the same things could be said for hospital patients who die. At some stage in their progression towards death, they are vulnerable and at risk of death. They may lack capacity. And so that's not enough. And it's well established, as we've seen, that the positive obligation does not arise in that context of those cared for in hospital but who die. At that point was, we think, well made with respect by Lord Justice Jackson in the Court of Appeal in Rebone. We don't have the Court of Appeal's judgment in Rebone before the court, but we do have Lord Dyson's approval of what he said. That's in volume 2 of the authorities, at tab 22. And it's paragraph 21 of Lord Dyson's speech. Second sentence, it's clear that the existence of a real and immediate risk of life is necessary but not is a necessary but not sufficient condition for the existence of the duty. And then this is because, as the Court of Appeal said, a patient undergoing major surgery may be facing a real and immediate risk of death. Yet the Powell case shows that there is no Article 2 operational duty to take reasonable steps to avoid the death of such a patient.
Well, that's all now been explained in Fernandez, insofar as we're going to get an explanation, and it's subject to the two carve-outs.
It is, but the point that I'm seeking to make at the moment, what Lord Justice Jackson said was a patient undergoing major heart surgery may be just as at greater risk of death as a schizophrenic patient with suicidal ideation. They were his exact words. And so the fact of the lack of capacity, the fact of the vulnerability, it is not enough. It's not enough to show that the deceased was a person who lacked the ability to make decisions as to their welfare, medical and other needs. Otherwise, in all medical cases, at some point, Article 2 will become engaged.
What is enough?
Well, I'm not positively suggesting a solution to that problem.
So we just come back to the facts of the case.
So if I said yes, that would be an unhelpful answer, and it would be suggesting a solution. I'm not going that far. I'm doing exactly as I think my lord did in Goodson, laying before the court some authorities.
And we're very grateful for that, and I hope you'll forgive me occasionally for trying to press you beyond the parameters that you've set yourself. But
Yes.
and we have in Rebone, in Lord Dyson's judgment, reference to a whole series of different things which holistically, on an evaluative basis, may take a case into Article 2 territory. In this jurisdiction, we like clear tests which can be applied by those at all levels without difficulty, rather than simply saying, well, it all depends on the facts, because that leads to inconsistency and problems. But we're trying to mirror Strasbourg jurisprudence, which has had its own difficulties over time.
Yes, and as I said at the outset of my submissions, this coroner will be at the front of the queue of those who were asking for a taxonomy, as I described it, of the kind that speaking for myself, the common lawyer reaches for instinctively. Where does that leave us? That the appellant says that the coroner failed to apply the Rebone test, and if he had have done so, the decision would have been that Article 2 was engaged. There's two elements, it seems, to that submission. The first of which is, if the Rebone factors had fallen to be taken into account, and were taken into account, then Article 2 would be potentially engaged. Right? Insert the word potentially there deliberately. at the second stage of it wasn't put expressly this way by Miss Butler-Cole, I think is implicit in her submissions, that if the answer to that first question was yes, then the second part of the question is, then what test applies? One doesn't immediately, applying the Rabone criteria, if I can call them that, immediately then jump to the conclusion that the investigative duty applies. She appeared to submit that what then happens is one applies the Osmond test. As my Lord Chief Justice did in Tyrrell. And I simply point out that's not the approach that has been taken in the medical care cases to define the triggers for the departure from the normal rule, the exceptional circumstances. And so a question must arise as to why it should be the Osmond test that ought to apply at this second stage of the enterprise, it being common ground that this is a case which involves alleged failures by healthcare providers. And so the appellant's case is that at this second part of the test, if you pass through the Rabone criteria, apply those to the facts of the case, one then, if one has got an answer which says, because of the vulnerability, because of the dolls, because of the background, because of the alleged system errors, one is potentially in Article 2 territory, then what test should apply? It's the Osmond test. The question arises is whether there was a real and immediate risk to Jackie's life, of which the carers, the paramedic, and the doctors, all the doctors, knew or ought to have known, and that they then failed to take measures within the scope of their powers reasonably to avoid them. I make no submissions on that second part of the test. It's quite apparent that the coroner didn't consider the first part of it. You would have seen that that was completely a function of the submissions that were made to him. The submissions made to him from start to finish were not that the Rabone test ought to apply. Everyone, in particular the appellant advocates, suggested that this was a case where one had to determine whether the exceptions set out in Parkinson had to apply. I don't make any submissions. I suspect Miss Watson will, on that second stage, the real and immediate risk, of which, a real and immediate risk of death, of which the relevant providers knew or ought to have known.
Well, here one runs up against something which is really quite difficult, or at least it seems to me it's quite difficult conceptually in this whole area of applicability of the procedural obligations to inquests.
Yes.
The one thing it's clear a jury cannot do, nor is it a function of an inquest, is to assert or find a breach of Article 2 operational duty.
Yes.
That's prohibited under the statute. And Middleton tells us that if there are reasonable grounds to believe that there has been an operational breach, then the jury must express a view on the central issue or issues in the case, and do so in the way that we've seen in paragraph 37. So we have an investigation that is designed in part to lay into the public domain and for the benefit of particularly relatives of those who have died, the material evidence, but not for the purpose of drawing a conclusion, but to make an observation, or 2 or 3, or as you tell us, maybe 40.
Yes.
Which give a hint as to some of the underlying circumstances. So we seem ourselves to have caused, by which I mean we, the domestic legal order, has heaped confusion on top of something which is quite difficult to grasp in the first place, as the Strasbourg court itself has indicated.
And, my lord, it's worse than that, because the coroner will make a decision on the applicability of Article 2 in an Osmond test case on a Galbraith plus basis.
Yes.
He won't be determining that there was an immediate risk. He will simply say that there's sufficient material for the jury reasonably to conclude, when properly directed, that there was. He will then direct the jury that they've got to consider whether nurse A, paramedic B, or Dr. C knew or ought to have known that there was a real and immediate risk to life. So he hands the question over to the jury.
Which they're then not allowed to answer.
Which they're then not allowed to answer, but one finds answers habitually in narratives.
Well, that's not consistent with the statute.
No. But one can think of the gymnastics required to be performed. The coroner has told us that in order to include within our narrative an answer to a question whether or not nurse A, paramedic B, or Dr. C's conduct was inappropriate or appropriate, was a failure or not a failure, was an opportunity missed or not, we first got to pass through the gateway of real and immediate risk. We're not allowed to answer those questions with a positive or a negative answer unless we have satisfied ourselves of the condition precedent first. And one therefore finds it very difficult for jurors to perform the gymnastics required of having to pass through that gateway but not say so. Because a different part of the coroner's direction will tell them not to. Not to include on the face of the record of inquest any conclusions as to whether or not there was a breach or a violation of Article 2.
So would the series of questions now be prefaced with a question 1, was there a real and immediate risk to life? If yes, go on to answer questions 2 and following. If no, thank you very much, that's it.
Yes, not a question, but the questionnaire will be divided up. So in relation to different entities involved or individuals involved, where different acts or omissions are alleged, the answer may be differential as between them, may be different between them. And so one has the gateway question in relation to each of them. Explain.
Each actor, as it were.
Yes.
And this is how we get 40 pages of questions.
I can't say that. That's not the... Hillsborough was something of
A very different case, yes.
Yes, involving a wide range of conduct
Yes.
by state actors and non-state actors. But that is a reason for extended questionnaires. Yes. So that's the difficulty that one faces. It being a necessary condition precedent to being able to express conclusions of a judgmental nature, that what the jury has found the relevant actor knew or ought to have known of a real and immediate risk to life, but then being prohibited from saying so. Lords, I haven't, my lady, I haven't got anything additional to say on grounds 2 and 3, consistent with the position that we've adopted in these proceedings.
Yes.
I just turn my back on the court.
Of course.
Unless there's anything I can try and help the court with. Those are
No, thank you very much indeed, Mr. Beer. Yes, Ms. Watts.
My lords, my lady, as you know, I appear on behalf of the interested party in this case, United Response. United Response are the private provider who were responsible for the residential unit in which Jackie Maguire was living for some 2 decades prior to her death. I would like to indicate that I too agree with the other parties and indeed the court as to the need for clear guidance for both coroners and indeed for the courts in determining when Article 2 is engaged in the context of any inquest. This is, as the court knows, a very sad case in which Jackie Maguire died in hospital at the age of 52 from a perforated gastric ulcer leading to peritonitis. And we formulate the central issue in this case as follows. It is whether the coroner was wrong in law to determine that the state's procedural obligation under Article 2 was not engaged in the inquest. In this case, the coroner had to make a decision on the material before him, whether it was arguable that the state breached the substantive procedural duty under Article 2, and having heard all of the evidence in this case, and indeed having had that evidence tested, he determined that it was not. I intend to approach my submissions broadly in 4 parts. First, I would like to look very briefly at the coroner's decision, to which I don't think the court has yet been referred, or certainly the court has not yet been referred to it in any great detail. I would then propose to highlight some of the salient underlying facts that are relevant in my respectful submission to the central issue in this case, and namely whether Article 2 is engaged. I had hoped to do that briefly, but in light of the submissions that you've heard from my learned friends about the poll, there will be a need to address you a little more fully, I submit, in respect of that evidence. Thirdly, I will address the relevant legal principles insofar as they've not been addressed in earlier submissions, and I will endeavour not to trespass on the patience of the court and repeat submissions that you have already heard and go over principles that you are now, I'm sure, quite familiar with. Finally, I will address in turn each of the 3 grounds of appeal. In light of the time that we have, I anticipate concluding this afternoon with a review of the coroner's decision. And you will find that in the core bundle at volume 2, and it begins, forgive me, at page 726. In fact, the transcript at 728 is where the coroner resumes his consideration of the application of Article 2. It may be more helpful for the court if I use the tab references, so I will endeavour to do that as we go through. It's tab 8, core bundle volume 2, beginning on page 728, where the coroner explains that he has resumed the inquest into the death of Jackie Maguire and wishes to consider whether Article 2 remains engaged. As the court is now well aware, the coroner had made a determination much earlier in the proceedings at a pre-inquest review hearing that Article 2 was engaged, and he explains at page 728 at E to G that the court felt that Article 2 was arguably engaged at the low threshold based upon submissions that had been received from the family, and that would be the view of the court. The court was taking into account the test in Osman in the United Kingdom. Did the state know, or ought to know, there was an immediate risk to the life of the deceased, and failed to take measures within the scope of its powers? He should have gone on to say to prevent that risk. He was, when determining that Article 2 applied at that early stage, considering, in my submission appropriately, the Osman test, he went on to indicate that he had received further submissions, On page 729 at B, he notes that those submissions included submissions from counsel on behalf of the family, in which submissions were made in respect of the applicability of Rabone, and in particular the judgment of Lord Dyson, in which he had identified a number of factors relevant to determining whether any obligation may arise. And I hope in due course to trespass on the court's patience and go back to the Rabone indicia, as they are often called. But it's quite clear that the coroner had received further submissions and had in mind those indicia when he was considering, or I should say reconsidering, the decision on the application of Article 2 at this point of the inquest. He goes on to note that he had received the significant decision in the case of Parkinson, and at F he says, I suspect I would have indicated that we were going to be holding an Article 2 compliant inquest in any event, and I would have proceeded to hear the evidence before reaching the stage where I think we are at now, whereby the legal position does need to be reviewed prior to summing up for the jury. He continues his consideration of the authority, in particular of Parkinson, over the page on page 730 at D, and he specifically refers to, and indeed sets out in his short judgment, paragraphs 82 to 91, again paragraphs to which the court has already been referred, but paragraphs which in essence provide a thorough and comprehensive review of the principles distilled by the court from both the domestic and Strasbourg authorities regarding the application of Article 2. That, of course, it includes the principles distilled from the Fernandez case. At page 731 at F, the coroner continues his consideration of the application of Parkinson, and he notes at this point that he considers this case to be one which could be categorised as a death in a healthcare context. Or he says at H, for Article 2 to remain engaged post-Parkinson in this healthcare context, it seems to me that the court would need to be of the view that this matter falls arguably into an exceptional context, and that we are dealing with a systemic failing or failings in a healthcare context. And you will note then that he goes on at page 732, at the top of the page at A and then again at E, to note that the submissions that he had received on behalf of the family at that stage focused on the alleged systemic failings, and indeed appeared to accept that the coroner was right to consider this to be a death in the healthcare context. May I take the court on to page 734 of the bundle, where the coroner begins to set out his conclusions. At G, he states there are arguably individual failings, and the court feels that post-Parkinson we are not dealing with a systemic issue, and Article 2 is not engaged for that reason. He then goes on to consider the exceptions and states that in terms of whether we are dealing with an exceptional circumstance, again, reviewing the evidence about the period we are talking about, the 21st of February 2017, and significantly in my submission, he notes, in the context of real and immediate risk, without going back to repeat Mr. Perfect's submission that I outlined earlier, it seems to me that the necessary grounds for us to be dealing with an exceptional circumstance purely based on that criterion alone are not met. On page 735, his final conclusions coming back to the case of Parkinson, he concluded that essentially Jackie Maguire's death was associated with medical treatment, and what was being alleged amounts to no more than medical negligence at B to E. And he makes a finding that there was no basis for any breach of the general duty or systemic duty, and he found no evidence that Jackie Maguire's life was knowingly put in danger by the denial of access to life-saving treatment. At that point he goes on to consider other matters, but it is clear that the coroner has considered this to be a case in which the allegations of failure or the concerns raised by the family were concerns arising from the provision of medical treatment, and that they could properly be categorised as allegations akin to allegations of medical negligence, and on that basis he considered this to fall within the category of healthcare case. Nevertheless, he has also received submissions and considered the test set out in Osmond, that is the test of real and immediate risk, and that has formed part of his reasoning. So far as that decision is concerned, as set out in my skeleton argument, at paragraph 16, the impact of that decision has, as I think has been agreed by all parties, no effect on the scope of the inquiry that the coroner did or indeed was required to carry out, whether Article 2 was engaged or not. And there can be no question, indeed I understand from the submissions of the learned friends about the poll that it is accepted, that the facts were fully, fairly and fearlessly investigated in this case. Again, there is broad acceptance by all parties that the impact of a decision as to whether or not Article 2 is engaged in an inquest is not one that affects the scope or the rigour of the factual inquiry, but widens the meaning of how in the context of the 4 statutory questions that are required to be answered, and that they may, and only may, affect the verdict or conclusion, as we must now call it, and the findings of the jury. I stress may, as the decision on the application of Article 2 only has the potential to affect the form in which inquest conclusions may be framed by a jury. And indeed that was made clear in paragraph 6 of the judgment in Middleton. If I may just go back to that for a moment. The court will find that in the authorities bundle 1,
tab 7.
page 149 in the bottom right hand corner. The change to the interpretation of how in the context of the Act is set out at paragraph 35. As you've already heard in submissions from a learned friend, Mr. Beer, by what means becomes by what means and in what circumstances. But at paragraph 36, the court says significantly this will not require a change of approach in some cases where a traditional short form verdict will be quite satisfactory, but it will call for a change of approach in others. In the latter class of case, it must be for the coroner, in the exercise of his discretion, to decide how best in the particular case to elicit the jury's conclusion on the central issue or issues. This may be done by inviting a form of verdict expanded beyond those suggested in Form 22 of Schedule 4 to the rules. Those would be the short form verdict. It may be done, and has, even if very rarely been done, by inviting a narrative form of verdict in which the jury's factual conclusions are briefly summarised. Of course, in this case, it always remained a matter for the coroner to determine how best to elicit the jury's conclusions. And in fact, as the court has heard, the jury returned a short form conclusion in box 4 of the record of inquest, but a narrative, neutral statement of fact in box 3 in answer to the question how. And the court has the record of inquest in the supplementary bundle at tab C1, pages 487 to 489. We of course accept that in the context of the coroner's determination that Article 2 was not engaged, that narrative was by necessity non-judgmental, whereas had Article 2 been found to be engaged in the context of this case, it would have permitted the coroner, would have been within his discretion to direct the jury that they could return a judgmental narrative.
Yes. Well, now, would that be a convenient moment to pause until tomorrow morning?
My lord, it would, and I would certainly be moving on then to the facts, and I would hope overnight to be able to review and refine my submissions in the hope that I can be shorter than I might otherwise be.
Yes. And just two points, if I can throw out generally. The first, it would certainly help me to have some sense tomorrow, Ms. Butler-Cole, of what you would have been submitting to the coroner should flow from this. That's the first thing. And the second thing is that given that, as I understand it, it's accepted on all sides that the inquest performed the central functions of an Article 2 compliant investigation, namely full exploration, public venting of all the issues, and the appropriate involvement of the family, see Jordan, what the appropriate remedy might be in the event that the appellant were to persuade us on the legal issues. Well, thank you. We'll see you at 11 o'clock tomorrow morning.
She was subject to result. It wasn't just...
It carries on.
That's the effect. It's a vulnerability.